On May 5th, 2026, deputies with the St. Lucie County Sheriff's Office served an injunction on Second Amendment activist and YouTuber Michael Taylor, also known as the Armed Fisherman. Earlier that year, Mr. Taylor had been charged in Pinellas County, Florida, with stalking Clearwater City manager Jennifer Poirier and was found not guilty by a jury. Following the acquittal, Ms. Poirier filed a petition for a stalking injunction against Mr. Taylor in Pinellas County, and a temporary injunction was entered on May 5th, 2026. Because Mr. Taylor resides in Port St. Lucie County Sheriff's Office deputies were dispatched to serve the injunction. Mr. Taylor filmed the encounter and then shared it on his YouTube channel.
Into contact. It says respondent shall have no contact with petitioner unless otherwise provided. It says respondent shall have no contact with petitioner, not directly or indirectly contact petitioner by mail, email, fax, telephone, through another person, or any other manner, including electronic means or use of social media. Further, respondent shall have no contact or have any third-party contact anyone connected with petitioner's employment or school to inquire about petitioner or to send messages to petitioner. That means no telephone calls, no text messaging, no Facebooking, no Instagramming, no Snapchat.
About her. About her.
You cannot contact her.
As long as I don't say nothing about her, I'm good.
You cannot contact.
If I can talk all this shit I want to talk about Clearwater, but long as I don't talk about her directly.
You cannot contact her
directly
or indirectly.
Okay.
Okay, and not through another.
Well, no, you just said indirectly.
Yes.
Well, she works for the city of Clearwater, and I talk shit about Clearwater. So is that indirectly, or is that because as long as I don't say. You're the.
Look at me.
I'm looking at you.
I'm not an attorney. I can't give you legal advice. I can only tell you what the paperwork says.
This
not
is
indirectly not directly or indirectly contact the petitioner.
Of her. Long as I don't talk about her.
You cannot contact the petitioner. All right. Contact.
Okay. What else?
Number 3, firearms. It says respondent shall not use or possess firearm or ammunition.
What?
Listen. Respondent shall surrender any firearms and ammunition in respondent's possession to the St. Lucie County Sheriff's Department.
And she's not feral or anything like that. Right there.
Right there. What I'm going to do is I'm going to write a.
It's fine, man. Just take the gun and be out of here. I don't want to hear nothing else. Just if you got to take the gun, take the gun.
Okay.
Thank you. Have a good day.
No other ammunition or anything?
No.
We're not being rude to you.
I know.
Try to be nice.
Please. Please. I know. I'm not being aggressive towards you. You've got my gun. We're done. Right? We're done. Right? We're done. Right? We're done. Right?
Okay.
Have a good day. Hi. Yeah, because I want my gun back.
So listen.
I'm not freaking out on you guys. Listen. Here, Linda, listen. Just give me my receipt and let me be about my day.
I gotta write it out.
What's your name?
You're gonna have it. Well,
don't say right here, please. What's your name?
Jose Estrada.
Thank you. Your name?
Deputy Arteche.
Thank you. And badge number?
319. I'll give you my business card.
It's fine. We'll go through all that. Your name and badge number?
Here's 200.
Thank you. Your name and badge number?
Sergeant Verveneer 179.
All right. And yours?
Lieutenant Flowers 134.
Thank you very much.
Thank you for being cooperative.
I'm not. I don't even know what this is. You are coming from Pinellas County.
No, we work for St. Lucie.
They sent you to come here from Pinellas County, and I just got found not unanimously not guilty for what is going on. I was found unanimously not guilty, and now I got to deal with a civil suit.
It's not a civil suit.
What is it?
Okay. So an injunction is just it's a civil matter that still is resolvable. You're going to go to court on the
I can't.
You need to present your side to things. It could be dismissed on the 12th. We don't know.
But you just took my firearm.
Yes, sir.
Is that fair to me and my family?
The judge asked for it. The judge required it.
Is that fair to my? It's not that I have a problem with the judge. The judge already. The court already decided that I was not guilty. and they didn't take my firearms away when I got hit with the stalking charge, and now here I am with an injunction for a civil, and now you're taking my gun. How? It's not how's that unfortunate? Tell that to my wife. Tell that to my daughter. Just imagine if somebody kicks in my door tonight and they kill my family. You're gonna be saying, "Oh, it's unfortunate that you didn't have your gun." Is it unfortunate? Welcome to YouTube too. Yeah, you guys know I'm a YouTuber.
Mr. Taylor, we're treating you with as much respect as we can.
I treated you guys with respect, but you guys stole my firearm.
I'm not disagreeing with what I said.
Stole my firearm.
We're trying to be
I'm trying.
Professional to you as you are to
Can I walk over? I understand there's the halo law. Can I be within 20? Because I'm just looking for my property receipt.
He's bringing it to you.
Yeah. Can I go within 25 feet? I'm not gonna.
Yeah, you can walk over there with me, man.
Yeah. I'm not here.
He's just typing it up for you.
I get it, dude. I get it, man.
And look, we empathize for you, man. I understand what you just said about, you know, protecting your family and stuff like that. But just understand, I'm not the one that wrote that document. He's not the one.
Did you swear an oath to defend and uphold the Constitution?
Correct. But
what Pinellas County did from 4 hours away just violated my rights. So, and you're sitting.
Yeah, you're gonna have that day in court.
Take it up with them.
It's not going to be a day in court. It's going to cost you, the taxpayer, money. Like I said, man, I have no ill will. I have no nothing.
I just don't want you to be upset at us.
I'm not. It's not that, dude. At this point, you know something? Tomorrow, you might hear about a guy wearing his banana hammock and open carrying, because you know something? If she's going to try to come after me civilly, I need to make money. So I'm going to wear my banana hammock in an AR-15 on a corner.
We're not allowed to have any guns
You
right
can't
now.
have any firearms.
You get arrested.
Oh, so no firearms?
No firearms. Do you have any other firearms?
No. I was going to call my buddy.
So if you have any firearms,
No,
I'm saying, like, if tomorrow,
No.
this case is clear, if you walk around with a gun,
Well,
you get
I've got
arrested,
to.
violate your injunction.
Well, right now I have a video I'm about to upload to YouTube, and
Past videos, that's
Okay.
past. Anything from here on out, that's different.
Yeah,
Past
okay.
videos, that's
So right now, from here,
from today until this is
and dealt with,
Right.
no guns.
Tomorrow.
I can't call my buddy and say, hey, can I borrow a gun for a day?
Don't even touch it.
All right, fine.
You have a copy of it. Read the whole thing whenever you go inside.
Yeah, I'm trying to stay 25. I think I'm 25 feet, right?
You're talking to us right now.
Yeah, and I have no ill will. It's just like, this is f***ing bullshit. Dude, I was 9 months with an ankle monitor. Look at my ankle. You see this? You see this? That's a callus ankle monitor for 9 months. I go through trial, get found not unanimously not guilty, and then here we are again.
Here, take that back.
Thank you. Is there a way I can get the light back? If it's possible. I don't know if it's. It should come off with just like a real. You know the deal.
Yeah, when this is all done with, you go get your.
Well, dude, that's a $130 friggin' light. I'm like, I get the firearm, but that's not a firearm. That's just an accessory. I appreciate that. Thank you. Appreciate it.
I'm writing still.
Yeah. No, I got nothing but time. Like I said, I have no ill will. I'm not gonna hurt you. I'm not gonna, I've seen too many YouTube videos of people trying to aggressively come after the cops. That's not who I am. If anything, I'm not that person. And then whenever I deal with bad cops, then that's when the bad side of me comes out. You treat me with respect, I'll treat you with respect. But if you treat me like a piece of shit, and not to say you're treating me like a piece of shit.
Sounds like we've been treating you good because you've been.
Yeah. I'm not, and it's not your fault. It's Pinellas County.
Exactly, man.
They sent you to come here which is a bunch of bull. But at the same time, you're telling me now I can't have any firearm. I can't call my buddy. Second, like, this is all a bunch of bull stuff. You know, just imagine if it was you. For being outspoken about, you know, government corruption, government tyranny, government outreach, all that. Whenever I do that, here we are. I get my rights stripped away from me.
Mr. Taylor argues that the Pinellas County injunction violated his rights, presumably referring to the Second Amendment right to bear arms. In the 2022 case of New York State Rifle and Pistol Association v. Bruin, the Supreme Court held that the Second Amendment protects an ordinary law-abiding citizen's right to carry a firearm in public for self-defense, and that any restriction on that right is constitutional only if the government can demonstrate that it is consistent with the nation's historical tradition of firearm regulation, a standard that significantly narrowed the circumstances in which governments can restrict public carry. Applying this framework, the First District Court of Appeal of Florida struck down Florida's open carry ban in the 2025 case of McDaniels v. State, and the Florida Attorney General subsequently directed statewide non-enforcement, making open carry legal for eligible adults as of September 25th, 2025. Now, we covered the arrest that led to the McDaniels decision in a previous episode of ATA, and we've included a link to this episode in the description down below if you're interested in learning more about how the open carry ban in Florida was overturned. Now, despite the lawfulness of open carry, under Section 784.0485 of the Florida statutes, any individual who is the victim of stalking may file a verified petition for an injunction for protection in circuit court, and if it appears to the court that stalking exists, the court may grant a temporary injunction ex parte, pending a full hearing, and may grant whatever relief it deems to be proper for the situation. Within 24 hours of issuance, the clerk of court must electronically transmit the temporary injunction to a law enforcement agency in the county where the respondent resides, who must then serve it upon the respondent as soon as possible. Now, as for the constitutionality of using this statute to confiscate Mr. Taylor's firearms, the Supreme Court addressed this question in the 2024 case of United States v. Rahimi, upholding a federal firearm prohibition for individuals subject to domestic violence restraining orders, and concluding that an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed, consistent with the Second Amendment. The Rahimi court's analysis, however, was grounded in an affirmative judicial finding of a credible threat of physical violence, and whether the record here supports an equivalent finding is not clear. Well, absent such a finding, if a court were to conclude that the ex parte issuance of the injunction, which stripped Mr. Taylor of his Second Amendment rights based solely on uncontested allegations and without an opportunity to respond, lacked the historical grounding necessary to meet the Bruin standard, a constitutional violation could be established.
Not happening. Not happening, dude. You could ask me for anything right now other than my first and last name, and you already know that. And like I said, I just need a case number from both St. Lucie and I'll get it from, oh, you're all St. Lucie. Okay. I just saw a sheriff's. I thought he was Port St. Lucie. Dude, the funny thing is I was just out open carrying today. That's what I'm saying. I'm like, I just did it today, and is that against the
You didn't get served injunction.
until right here?
Once you got it served,
Yeah.
that point on.
Okay. Yeah, I know. I'm just. I know. I get it.
So
I just want to make sure we're not gonna.
oh, you're good. You're good. You're good. So this is the property receipt you asked for. Normally I get one anyway until you shut the door in that face, and I was like, what the heck? So there's two of them.
One for you, one for me.
One for you, one for me. Exactly. So I've listed down Glock with the serial number, Glock magazine, and 14 rounds of .45 caliber. I've already signed my portion.
Can you put hollow paints on there?
Because I don't want to get a bunch of, bring up quarter strip rounds, because I paid a lot of money to it.
Well, let me look at these rounds. Let me look at
Please.
these.
I'm telling you, man, ammo's expensive. You know, my ball ammo, I don't give a shit about. But whenever I put hollow points into a gun, and it's like $30, $40 a f***ing box, yeah, you best believe I'm gonna make sure I'm getting my hollow points back. Yeah, hollow point, hollow point, hollow point, hollow point, hollow point. All those are hollow points. Yeah,
I've seen the different colors.
Yeah, it's there's one that's I can't remember. One's like
yeah, usually we don't listen like brands or anything.
Yeah, I'm not worried about the brand. It's just longs are hollow points.
Mr. Taylor surrendered his firearms peacefully, and the encounter ended without further incident. On May 12, 2026, following a motion from Mr. Taylor's counsel, the court amended the temporary injunction with respect to its firearms conditions, and Mr. Taylor subsequently went to the St. Lucie County Sheriff's Office to retrieve his confiscated firearms. After retrieving his firearms from the St. Lucie County Sheriff's Office, Mr. Taylor was openly carrying in Martin County, Florida, when he was approached by deputies from the Martin County Sheriff's Office.
Come on.
Not here. Huh? A violation of rights or anything like that. However, there is an injunction in place. Hold on. There's an injunction. There's an injunction. Violating your injunction. No, I'm not. We're going to get to the details. Right now, online. You know everything's going on. Listen to me. I'm not going to fight you guys. This injunction.
Let me explain it to you. I was just giving information.
The injunction, in possession of the firearm right now.
That just got overturned. Can I call my lawyer?
Look, to that fear in a minute.
Yep. Absolutely give you the opportunity.
Let's walk over here off the roadway, okay?
Yeah. Can you take my... Let me call my attorney.
We'll talk in a minute. We'll talk to the attorney, okay?
Yes, please. Before you actually take me to jail.
We're not taking you to jail yet, but you do have the...
I understand. I understand that. They just gave me my firearms back.
Who gave you the firearms back?
In St. Lucie County.
When did they give it to you?
Today.
Okay, perfect. That's why we're trying to get to the bottom of it. Because
all St. Lucie County. That's why. I understand that there's an injunction. The injunction from the judge said because of all this. Because
right now, I'm gonna
yes. Hold on. Be careful. Is
there one in the same?
Yes, sir. I like I said, if you want to take, I don't want you to take the firearms, but just
we're going to.
It's it's got a nice seal, and that's why
I want to just take the whole.
All you have to do is pull. No, just it's sucked on my belt. Just pull straight up.
There we go.
There you are.
Onto the legal side of it.
And then,
like Michael, like I was saying, we were just giving that information. Obviously, we're getting calls on you.
I get it.
On what you were doing.
I get it.
With this injunction, that's why we're here.
Yeah. And like I said, I'm
gonna take this off right now.
Yep. Hold on. There's a QD mount.
Mm-hmm. Perfect. Yep. I'll get.
And then I'm not, like I said, I'm not resistant.
No, you're not at all. You're good. You are good.
I don't have any more weapons.
Okay. Wallet, I'm assuming.
Wallet, cigarettes, lighter.
Move your feet apart, Luke. All right.
You good?
Yeah, if you want to sit right here, you're good, man.
Like this literally didn't happen. Like literally just got him back.
That's why we're going to. Where's your injunction?
Well, right now, they put me in handcuffs because of the injunction. And we just went through the injunction where they gave me my firearms back, and you were the one that orchestrated that. And any one of you that wants to talk to my attorney about this, because I'm not trying to go to jail, but I can use it. This is Martin County.
Listen, if you have an active,
I haven't.
Active injunction
That's what I'm trying to get at. That's what I'm trying to tell you is that this injunction just happened.
We just got
2 days ago.
County. As of this point, right now, it's active.
It's not happening. It just happened.
It is absolutely active.
Yes, sir. I have my attorney, dude.
You can speak to your attorney.
But he's telling you that this just was.
Is this Martin County?
Yes, sir. literally just got the hand.
I was just out open carrying on a sidewalk.
And they saw the injunction, and they said it was still active. The firearms part. That's correct. The firearms provision. If you look at letter E on the injunction, letter E says that my firearms have to be returned to me, and they literally got returned. I was at the St. Lucie Sheriff's Office. Yes, sir. That sounds good. Like literally at 10 o'clock this morning, I went to St. Lucie to pick up the Glock that you just picked up, that you just took. I literally was just there.
The deputies handcuff Mr. Taylor, claiming that he is violating his injunction, and Mr. Taylor and his attorney explain that the firearms provision of the injunction has been amended. Under Section 784.0487 of the Florida statutes, refusing to surrender firearms or ammunition when ordered to do so by a court constitutes a first-degree misdemeanor, and openly carrying a firearm in apparent violation of an active injunction's firearms provision could provide a basis for arrest under that same provision. Now, it is important to understand that despite the fact that the deputies appeared to be responding to calls about Mr. Taylor openly carrying a firearm, which is entirely lawful in Florida, the issue was not that they believed open carry to be illegal. Rather, they seemed to believe that Mr. Taylor was violating an injunction containing a firearm prohibition that remained active. Although the firearms provision had been very recently amended to eliminate the restriction and allow Mr. Taylor to possess firearms again, it is possible that this updated information was not available to the deputies. And if this was the case, a court would likely conclude that the officer's seizure of Mr. Taylor did not violate the Fourth Amendment, despite the fact that he did not actually violate the injunction. As the Supreme Court explained in the 2014 case of Hine v. North Carolina, a seizure may be permissible under the Fourth Amendment even when the justification for the action is based on a reasonable factual mistake. Accordingly, if a court were to find that the deputies' belief that the firearms provision of the injunction remained in effect was objectively reasonable given the information available to them at the time, a seizure would likely survive Fourth Amendment scrutiny, notwithstanding the recent amendment to the firearms provision.
Like just fluid zip happened. Like, you want to see the video of the at the St. Lucie County Sheriff's Office and them giving my firearms back?
Yes, James, some games. Nope, some beach options.
Even if I knew that I couldn't have possessed firearm, you think I'd be out here today? Like, that's the crazy.
His attorney is trying to call the sheriff's office talks.
Your vehicle delivered by Kyle E. Scott.
Alright, so unfortunately it is, right now we're going to have to take you in, violation of the injunction.
It is unclear exactly what occurred after Mr. Taylor was arrested. However, based on the title of Mr. Taylor's YouTube video, it appears he was released shortly after he was arrested, presumably without any charges being filed. As of the date of writing this episode, the stalking injunction case remains pending. Overall, the deputies of the St. Lucie County Sheriff's Office and the Martin County Sheriff's Office get an A for conducting themselves professionally throughout both encounters, acting on information reasonably available to them at the time, and for handling a legally competent complicated situation without unnecessary escalation. Both sets of deputies handled their respective encounters without confrontation, and the Martin County deputies demonstrated a clear understanding that open carry is lawful in Florida, arresting Mr. Taylor not because of the manner in which he was carrying, but because they believed an active court order prohibited him specifically from possessing firearms. Whatever criticisms exist about the underlying injunction framework and its constitutional tension with the Second Amendment rights discussed earlier in this episode, it's not the role of law enforcement to decline to enforce a court order on the grounds that it may be legally vulnerable. Officers are obligated to act on the law as it exists, and the constitutional framework governing mistakes of fact recognizes that officers acting in good faith reliance on a court order that has been modified without their knowledge are not acting unlawfully, even when the arrest ultimately proves unwarranted. In this situation, the injunction was issued in Pinellas County, it was served in St. Lucie County, and Mr. Taylor was encountered in a third county entirely, making it entirely foreseeable that the Martin County deputies would not have had current information about the amendments. This interaction highlights how the intersection of rapidly evolving court orders and multi-jurisdictional enforcement can place officers in genuinely difficult positions, and even, in situations like this, lead to unnecessary arrests based on outdated information. Now, Mr. Taylor also gets an A for exercising his Second Amendment rights lawfully, maintaining a respectful demeanor during two separate law enforcement encounters, and pursuing the appropriate legal channels to challenge the conditions of the injunction. Mr. Taylor openly possessed and carried his firearms in compliance with Florida law, and in recognition of the rights restored to him by the amendment to the injunction's firearms provision. During both encounters, he voiced his objections clearly, requested the opportunity to contact his attorney before being taken into custody, and complied physically without resistance throughout. His decision to challenge the firearms conditions of the injunction through counsel rather than through noncompliance was both legally sound and practically effective, resulting in the amendment that restored his rights shortly after the initial injunction was entered. I commend Mr. Taylor for his composure under circumstances that would test anyone's patience, his effective use of legal counsel to vindicate his constitutional rights, and his commitment to documenting these encounters so that the public can evaluate them for themselves. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in exploring the legal nuance beyond the body cam.